Mrs. Ramsey, I've got questions on a handful of topics from core participants. I'm going to ask you questions, first of all, about discretionary grants. Is there a requirement to establish that you have a need for an item for which a discretionary grant is sought?
In general terms, yes, we'd normally seek an understanding of why the request is being made.
You've indicated that you've accepted every application so far that's been made to you.
That's correct.
So the applicants have always been able to make that out so far to date.
Yes.
Does the need for a payment for an item have to be due to the person's infection?
No. As a consequence of the infection, they have become members of the scheme, as it were. So that has already been dealt with and accepted. No.
Do you know who made the decision not to means test those applications?
I understand it was something that was discussed when we were finalising the staff guidance. So it is something before my time, but when we were sort of finalising the staff guidance, means testing was included in the SIBS staff guidance, but we considered that we weren't really equipped to set up a means testing mechanism, and that it felt it was probably not proportionate to the actual small grant scheme itself.
And so was that a decision taken by Wibbs or by the governance group in conjunction with the Welsh Government and the other members?
It would have been in the context of the governance group, yes.
Are discretionary payments made to beneficiaries who do not receive regular payments? So, for example, children who are not children of beneficiaries who are not dependent children, parents, carers, and so on.
No, it is only open to members of the scheme. So it would include widows, and it would still include widows who may not still be in receipt of regular payments, but it wouldn't be extended to those as it's currently configured.
And we looked at the, I can't remember now which document, I think it's the Directions Schedule 5, which looked at discretionary payments saying they could be made to widows, to partners and dependent children. Is that and infected beneficiaries? It's to that cohort of beneficiaries. Yeah. I asked you questions about information that was on the website about the information about the existence of the discretionary grant scheme being on the website, and you said that you weren't sure whether it had been on the website previously, but it wasn't when it had been put onto the website shortly before you did your witness statement. Do you know how or if information that there is discretionary grants, that there is a discretionary grant scheme was disseminated prior to that information going on the website? Sorry, that was a very inelegant question. I don't know if you understood that.
I think I do, and I think because that would be before my time, it would be something I'd need to confirm with others. Okay. And follow up in the written response.
Are you aware during your time of any information about the existence of the small grant scheme being disseminated to the membership either through newsletters or any other means?
No, I think it's mainly been the website, but now we've got it on the website would be what we've been relying upon, in addition to anybody who would have contacted or had support provided by the welfare team, because they would have an awareness of it and would signpost or direct people to the grant scheme as a form of support.
I'm going to ask you some questions now about income top-ups. For those transferring from the AHOs to the Wibbs with income top-up in place, were the payments continued by Wibbs at the same level as they had been paid under the AHO?
That's my understanding.
Was any inquiry undertaken by Wibbs as to why the payments were made by the AHOs, or whether or not they were at the right level and so on?
Not so as far as I'm aware, no.
Do you know why not?
No, I'm afraid I don't.
And is that because it was before your time?
Yes. I wasn't in post at the time of the transfer when the arrangements with the AHOs was being worked through and sorted out.
Do you know whether income top-up payments are made to beneficiaries who do not receive regular payments? So those beneficiaries I identified earlier, like non-dependent children or parents or carers and so on.
I don't believe so.
I'm going to ask you some questions now about the advisory support group or network that is under consideration. Are you able to give any more information about the fundamental objectives of such a group, or what would be different about it to the governance group?
So if I start the other way around. So the governance group is around the oversight of the day-to-day operations of Wibbs in the main, and you've got a copy of the terms of reference which goes into more detail. What we see the support network group being more around is something that Dr. Coffey and our counsellor would develop really through the network itself to determine, what they want out of the group, what role they would want it to fulfil for them as beneficiaries. So very much a co-production approach in that sense. But what we would hope we would gain from a governance group perspective is how we go about nominating that server user to sit on the governance group as well. So that would be what we would look to as one element to get out of the group itself. But it's important to state that the group is for its own purpose in terms of the beneficiaries themselves and what they want to use it for, and how they want to see it develop. And that is a piece of work that our psychology team would be developing and leading.
So the second part of that question is how, whether there would be a formal way for the support group to influence the governance of Wibbs. And I think your answer to that question is through the vacant seat on the governance group.
Yes, that's how I would envisage it. But if other suggestions or recommendations were put forward by the beneficiaries themselves, then we'd certainly consider those and take that on board.
We looked at the guidance on assessing, I'm changing topic now, looked at the guidance on assessing new applicants coming onto the scheme, hepatitis C infected applicants. And there was a paragraph in there that we were looking at the explanation for probability, on the balance of probability, and it referred to it being improbable that an injecting drug user was infected via a single blood transfusion. The question is whether or not Wibbs has obtained any expert evidence on the probability of an injecting drug user becoming infected with hepatitis C.
I understand that we did seek some additional advice because at a point in time we did reject an application on the basis of IV drug use, and that case went to appeals. So at the appeal stage, additional information was brought into the application. That's the only example I can call on.
Are you able to tell us how often applications are approved in cases where there is a history of intravenous drug use?
Not without needing to refer, no, I'm sorry.
Do you know whether there have been such cases?
Yes, we have.
And what kind of circumstances might lead to such an application being approved?
I think it is the balance of probabilities test. So we would consider the frequency of IV drug use against other factors set out in the application.
And are you able to tell us whether or not anyone that's been identified as having been potentially infected as a result of a look-back exercise then being rejected by Wibbs on the grounds of intravenous drug use. Is that something you have come across?
I couldn't pull that information to hand now. No, I'd have to look into that.
I'm now going to ask you some questions about clinical plausibility and Wibbs's practice of obtaining clinical advice on applications where there's no evidence of the treatment that's said to have caused the infection. You said that Wibbs often go to two particular haematologists for such advice. Can you explain, or could you explain to us why you refer questions relating to the likelihood of historic blood transfusions to haematologists? Would it not be more appropriate to refer it to, say, for example, if the treatment was arising as a result, say, of an orthopaedic injury, to an orthopaedic expert?
I think we also have sought advice from a microbiologist as well, from memory. I think these were advisors that we initially identified at the concept of Wibbs, where they would feel unable to offer an opinion. They may suggest that we do such that, contact an orthopaedic surgeon. We might ask for a recommendation of the name, and then we would follow it up with them directly.
So
and we have done that in one recent application, actually.
So is this right, that your first port of call might be the haematologist, and you would leave it up to their discretion as to whether they were competent, or whether it was something, it was an opinion that they could give you, and if not, you would go elsewhere?
I think that's fair, yeah.
I asked you questions about whether or not you informed the applicant that you had obtained such a medical opinion or advice, and I think your response to me was that information would be passed on. Do you give the applicant a copy of the medical opinion or advice, as opposed to just informing them of the fact that it's been sought?
I think we would, in the letter to the beneficiary, we would probably provide a summary of what questions we'd asked and what was provided back. I can't say with any certainty that we actually attach a copy as such. No, I don't believe we go as far as that, but we would certainly do more than just say we've contacted a medical advisor. We would give a little bit of a summary as to what question we'd asked and what their response had been.
And as a matter of principle, would you accept that it's important for that information to be given to the applicant so they know what has been said and what case they need to meet, if indeed they wanted to appeal?
Yes, and if they were to appeal, then they would receive that whole bundle of information as part of the appeal documentation pack. But I do accept the principle you've made, yes.
And last question that I'm going to ask you is a general one. You were asked in the Rule 9 to whether or not you considered that Wibbs achieved its aims. What do you consider the aims of Wibbs to be?
I think the overarching objective of the Wibbs scheme is to provide a prompt and responsive service to new applications, but also then to provide a holistic support service to existing beneficiaries and their families, so that we can offer as much support, and that we can, as a team, continue to learn what more we can do to help support them.
And is there a document or a source that you can go to where those aims are set out and defined?
I think in the main the aims are set out in the Memorandum of Understanding. They're not as neatly described in the directions, I would say.
So those are the questions that I had.
Well, thank you. I have three areas of questioning for you. The first is this, and it really arises out of what was said in your witness statement. We'll perhaps have a look at that. It's WITN 5665001 at page 23. And it's paragraph 113.
WITN 4506001.
Can we get that up, Shoemake? Page 23. Thank you. The question is, are these grants or payments, this is about discretionary grants, means tested? If so, why? Are the income brackets publicised? If so, where? If not, why not? Now, just dealing with discretionary payments, you say in your answer there, we may ask for income and expenditure information when requesting a grant as part of an overall benefit check. So that's about discretionary grants. And you repeated that a moment or two ago in evidence, and you described how part of the application form was for people to fill in details of income and expenditure. One of the benefits of not having means testing, one of the objections to means testing, is, or do you agree it is, that people should not have to fill in forms which may ask for intrusive personal financial details? Would you agree with that?
I would agree, but the intent in this circumstance is to see whether or not the welfare team may be able to access additional support, financial support or other, for the beneficiary. So that the intent behind it is different, I would argue.
Does it say that on the form?
It may not do explicitly, I accept that.
So what it might say on the form might be, please do not fill this in unless you think that we may be able to help you access other sources of help, or unless you want to see the benefits advisor.
I accept that point.
And that would avoid the sense of this is having to hold out the begging bowl, and may indeed put some people off applying at all.
Yes, I can understand why some may feel that way.
So perhaps some consideration might be given to amending that form to remove that particular problem. The second question really arises out of, you can take that down now, Shoemake, but could you put back up in its place WBIS 5063? Now, this is not a document which is published on the website, or is it?
Yes, it is.
It is.
It is.
So anyone who's wondering whether they can make a grant, knowing that they're eligible, would look down this list. I see. Respite care is included. And the respite care would be regarded as being paid then to the beneficiary.
Yes.
I'd missed that first time round. It's my fault. So the question that I was going to ask you falls away. But it's accepted as a matter of principle, is it, that respite care is really the need of the beneficiary, and not, although in one sense it's a need of the carer to have some respite, it has to be funded and paid for, and that's an expense which in the first place lies on the beneficiary.
I'm not sure I've understood fully the question. I'm sorry, could you repeat it?
It doesn't perhaps matter, but it just occurred to me when we went to that fairly quickly earlier on, I'd missed the fact that respite care was included.
Okay.
So that was what my question was going to be about. It's my fault, not yours at all. And I was just asking you to agree with the principle that respite care is actually a cost, not to the carer in needing to fund a respite period, but to the individual who is having care to provide for alternative care during that period.
Exactly that, yes. And we recognise that sometimes there will be additional care required as well, so we do have the additional amount there as well.
Now, the third question is really about the publicity in respect of the scheme. There have been a number of new beneficiaries suffering from hepatitis C during the time that Wibbs has been operating. That's obvious because you've dealt with cases where the criteria have or haven't been applied.
Yeah.
Now, a hepatitis C sufferer would not necessarily be haemophiliac.
I'm so sorry, Sir Brian, the Wi-Fi cut.
I'm sorry.
Start again. Oh,
somebody suffering from hepatitis C might have had that from a transfusion and not from part of treatment for their haemophilia.
Yes, possibly.
They wouldn't necessarily hear of Wibbs through the Haemophilia Society or Haemophilia Wales, and they wouldn't necessarily be alerted to the Wibbs website unless alerted in some other way. So you mentioned that there had been a leaflet sent round to GPs.
Yes.
How recently was that done?
We did that I think the start of this calendar year. We'd updated it to take account of the psychology team and the welfare team, and we've shared that by the practice managers network, because they're the ones usually responsible within a practice for disseminating such information.
And did you have any feedback as to the success of that leafleting campaign, in the sense that there was suddenly a number of new applications?
Not yet, but I do have at the forefront of my mind the current pandemic restrictions on GP practices. So it's something that we've agreed we will revisit with the practice manager network in sort of like the course of the year, really, to see whether or not there's more we can do. We also anticipate that we will need to update the leaflet, obviously, in light of the parity announcement at the end of March. So there'll be a second bite at it, if you like. I would anticipate during the second half of the year.
So that gap, if it is a gap, will be closed. Thank you very much. That's all that I have to ask.
Mrs. Ramsey, is there anything you would like to add?
I think just some final comments, if I may. I'd like to echo the comments that my colleague Dr. Caroline Coffey has put into the inquiry, and that is to acknowledge the resilience of our beneficiaries in Wales in their fight to have justice and to have their voices heard. And as a team, we certainly hope that the outcome of the inquiry brings them some comfort and the answers that they seek. I'd also want to put on record my thanks to the team as a whole. They're a dynamic bunch, and they work very well off each other, and are always really rooting for what more they can do to provide support to the beneficiaries. And to that end, if there are any suggestions or ideas that the beneficiaries have, we would really encourage them to get in touch with us and to make us aware of it. And as we discussed already this afternoon, if there are any other items that come to light during the course of the inquiry, if there is an appropriate means that those can be shared with us, then the sooner we can take those on board, the better.
Well, can I thank you very much for your evidence, despite the challenges of the Wi-Fi later on. You have been very helpful indeed, and I'm sure that those who have been listening will welcome the invitation at the end to let you know if they think there is any improvement which can be made in the scheme, which you think is a sensible improvement. So thank you very much.
Yeah, thank you.
Tomorrow.
Tomorrow, sir, we start off in the morning with Mr. Brendan Brown, who is the Director of Citizen Services at the NHS Business Services Authority, and he's going to talk to us about the English scheme. And then at 2:30, we have the Secretary of State for the Department of Health and Social Care, Mr. Hancock, and Mr. Vignal, who is the Director of Quality, Safety and Investigations at the Department of Health and Social Care.
So 10 o'clock tomorrow.